Any mention?
I think very important.
Any mention?
Yes.
Supplementary list item number 1.
What is virtual court, you know? Virtual court, you were saying? There's so many lawyers.
May it please, Your Lordship.
Yes.
Your Lordship, we filed an affidavit, Lordship.
Have you? Okay. Yes.
Hello, supplementary 1.
Yes, supplementary 1. You have received the affidavit.
Your Lordship.
So they are here online.
Yes.
Today is virtual hearing day. You could have still, you didn't come. There's a notification that Thursday is.
Hello, MC 43 can be considered. The amounts may be stayed.
What kind of prayer is that? You have to make out a case for staying.
Yes.
Have you seen the affidavit filed by them?
Yes.
So what do you have to say?
Whatever they mentioned, this is not the case. Actually, the remaining is dispute is.
MS Mirchang, I think a lot of disturbance comes from your side. From whose? Yes. No, okay.
My lord, in this case, the dispute is the difference of ITC income tax input tax credit avail.
No, you've seen your conduct. You see your conduct in the affidavit.
Yes.
Forget about the amount. Or forget about the liability. Have you seen your conduct?
My lord, actually he has appeared. He has appeared in the only one case. He has not appeared. Expiry was 1,28,000. Out of that, he has deposited amount. The tax amount. The other one, he has appeared, and he is.
I don't understand.
Yes, my lord. He has categorically
make concise and precise submissions. We are dealing with GST matters. Not a question. He has come. Other matter. We are dealing with which matter now? This is.
My lord, here
okay.
actually my contention is that demand is illegal. This is not maintainable as per the law, as per the section 16. So this is also settled by the Delhi High Court as well as the Supreme Court and Guwahati High Court also.
Yeah.
Demand has been raised on the difference of the 3B return and 2A return.
Any show cause reply? Have you put?
Yes. I have the reply to Sukos. Yes, my lord.
You put all these points in issue.
Yes.
Yes.
That is on record. At the time of argument, I can show all these things, my lord.
At the time argument.
Made petition, writ petition.
We are hearing it now.
So it comes down.
We are hearing it now. Yes.
Actually, my lord, the dispute can be seen. This page number.
You're not reading it. I think it's clear that it's a birthright.
Page number 88, I can see.
Yes. We allowed you to pay 8 lakhs and your
yes, sir.
Now it's been blocked again because you have not complied with.
My lord, when we reopen the case file, the is not functioning because there is a demand of 23 lakhs is lying in the screen.
This case. Yes, fine, this case. That has been fine. Yes. Yes. Now we take the miss case or the main case?
Miss case.
Yes, MS Marchang, where's Dr. Mosika?
Your Lordship, this matter requires a physical hearing, Lordship. So I'm praying if this matter may be taken up next week. Because we have some instructions, Lordship, with us, and we need to supply it before your Lordships.
But then it should have come in the affidavit. You want to file agenda?
No, I have not filed.
You don't want to file, yes. Affidavit.
Actually, the only dispute is
affidavit on behalf of the respondents to the in miss cases, miss case 43, to the prayer for stay has been filed. Stop. Just a matter for consideration after 1 week.
Highly obliged.
Yeah.
Daily list item number 1.
May I please, Your Lordship? This is an need appeal, my Lord. As per the last order, the private respondent number 9, the writ petitioner respondent, she appeared and seeking copy, but we served the copy and the notice was duly served to the respondent. So,
Is there a delay?
my Lord, already condoned, matter has been admitted, my Lord. So,
Then what is for today?
my Lord, Mr. KP sir, he was appeared in this matter for respondent number 9.
Where is he?
Idea, my Lord.
No, he's not online also.
My Lord, no, my Lord. The matter needs, my Lord, hearing. My Lord. I'll pray for fix it for hearing, my Lord. Only two.
Now, how do you know that all have appeared?
My Lord, appeared in the last order, my Lord.
1 to 6 time.
Yes.
What about 7 and 8?
My Lord, 7 and 8 is the school managing committee, my
Have
Lord.
they been served?
Yes, my Lord, served.
Where's the
the-
maximum of service?
certificate of service. My Lord, yes, we filed, my Lord, on, my Lord, 12th of March, my Lord.
Affidavit?
Yes, affidavit of service, my Lord.
1 second. 7 and 8. Hey, affidavit of service.
Last order, sir. Ready,
7 and 9.
Yes, my Lord, 7 and 9.
What about 8?
My Lord, 8, my Lord.
Wait, receive service.
9 is. My Lord, actually, there is no managing committee, my Lord. Presently, there is no managing committee in the school.
Lordship, kindly list the matter at the end of the board. Mr. Bhattacharjee is on his way.
On his way where?
My lords,
Yes, Mr.
He'll be
Mr.
kindly, my
SK
lord.
Hassan submits that as all the parties are represented, he pays a matter basis for hearing.
My Lord, after
It's a matter for
2
hearing
weeks.
after 2 weeks.
My Lord, 2 weeks. TP applies.
Great.
Item number 2.
Yes, yes. Sorry.
May it please your Lordship,
Your
learned
Lordship,
aid.
I'm appearing for the response.
Yes, Dr. Agarwal. Where's your reply?
Lordship AG is appearing today, but it doesn't seem to be.
yes.
But in any event, Lordship, we're
Yes.
bring.
Yes, where's your reply? Yes.
Lordship, affidavit in opposition has already been filed on the last date. The learned AG had prayed for time to file rejoinder.
May it please your Lordship, we're praying for a little bit more time to file
In
rejoinder.
terms of order. Okay. Yes. 2 weeks time allowed for rejoinder to the affidavit filed by the respondents. Is there-
Grateful, Lordships.
Item number 3.
Bring the food weeks.
May it please your Lordship. In this matter, we filed our affidavit, Lordship.
Who's
May I
for the-
please, Lordship?
Yes.
Lordship, 4 weeks time may be granted for affidavit in reply.
How much time?
Lordship, 4 week time. Lordship, the matter may be kindly taken up after 12 July, if possible.
Why?
Lordship, because
For the 3 weeks time allowed
the-
for rejoinder. Yes, thereafter and so on.
Item number 4.
In item number 4, I'm praying for some time, Lordship, to file our affidavit.
Lordship, for item number 4, I'm from the petitioner side.
Yes, okay. 3 weeks for a time has been allowed for affidavit. Yes.
Highly obliged.
Together with which one take
Yeah.
place. Yes.
Hearing. Supplementary list. Item number 1. Oh, sorry. 2.
This is fixed for
Submission of written argument. Your
other side they've given
Lordship, the written arguments are ready, Lordship.
from
You
the side of
it
the
for the petitioner, Lordship.
Mr. Siddiqui is appearing where? Oh, he's not here.
No, this is that Tolentine matter, Lordship. Tolentine.
You submitted.
Sir.
If party submitted the notice of submission, hearing concluded, judgment is reserved.
How's that?
Great rule.
Daily list. Item number 5.
My lord, there are connected meters 5 and 6.
No,
my learned friend. 5 and 6 are connected, my lord. So Mr.
Yes.
Asu is also there.
Yes.
In this case, my lord, we have challenged the jurisdiction and legal authority of the district council to issue patta in connection with the Nokpal land, my lord.
Yes.
So the district council had adopted a law by the name of the they have not passed the law, but they have adopted the law known as the Regarihus Autonomous District Land and Revenue Regulation.
That is green copy. Assam green Haru rules. Keep it ready. Yes. Yes.
I'm reading from page 102, my lord, of this green book.
Or the green book.
Yes. Page 102, start page 102 and 103. 103, paragraph 3, clause 3, I am reading, my lord. It is adoption of Assam Land and Revenue Regulation 1886 and the rules made thereunder.
Yes.
So, my lord, my submission is that the district council has no jurisdiction or authority to adopt a law, my lord. This authority was given in the Northeastern Areas Reorganization Act to the state, my lord. Under section 79, power to adopt the laws. But the district council has no authority to adopt any law. They will have to legislate by the council.
No, but isn't this their own legislation? This is the preamble. See, Government District Regulation number 1954 received the assent of the governor on 9. Yes. This is a regulation to provide for administration of land, assessment, collection of land revenue. So preamble.
Yes.
Whereas it is expedient to provide for the administration of land. So imagine the reason. What is never was never.
Lord, this,
yes. Yes, Mr. Siddiqui.
This should pass to the council, but there is nothing on record to show that it was passed by the council.
Okay.
They have only adopted it by clause 3.
Yes.
This power vests with the state government under section 79 of the Northeastern Areas Reorganization Act, not to the district council.
Yes.
So the problem
now let's see. Okay, one second. Where's that? Prohibitions of the council rules. Is it here in this compilation? The constitution of the council rules. Assam Autonomous High Court. Constitution of the council rules.
You have answered that one.
$30A. See, this one is emergency power. There is first emergency power when that's not in session. The council in session. It's like they're conducting election. Yes.
So, but under section 3 of the Constitution, even in an emergency, if a law is adopted, my lord, it should be placed before the district council session when in its next session, and it was never placed before the council, my lord, till date.
Never placed.
No, my lord, it was never placed. So therefore, its existence is in doubt.
Now, only one question before we, proceed.
Yes.
Now, this regulation was passed in 1954, right? 54. Now,
yes,
that is 26 plus. How many years? 46 years is how much?
It is almost 70. Yes.
72 years. So,
yes, ma'am.
do you think that after 72 years, when the regulation has been passed, there is any possibility of no matter even if see, the only thing you're challenging is the procedure adopted because in the part of the legislation of the council that you exercise your emergency provision and you adopted the Assam Land regulation, and that this adoption is it's like an ordinance which is not placed before the assembly or for the parliament, that has not been placed before the council in session, and as such it is an incompetent regulation, correct?
Yes.
That is for submission, okay.
Yes,
but you have to keep with the back of your mind that you're questioning a regulation that was made 72 years ago.
Yes, that is
yes. Yes. Yes, please proceed. Yes.
Now, my lord, the second point is that this land revenue regulation provides for issuing a patta, that is a Myadi patta, or it is called the periodic lease. Yes. Whereas the district council has no power to lease out or to transfer any land as per the judgment of the Citizen Survey, which is known to all, my lord. Under that judgment, it was held to the Honorable Supreme Court. Yes. That the district council cannot transfer land in any form. And especially here, when it is a Nokmal land, it is not the land of the district council.
So your argument is that since the district council have power to allocate land or to transfer, or
yes.
So the issuance of periodic pattas, okay, they don't have the competency to issue pattas. The transfer is not there. It's not there. In a 6th schedule, transfer is not there. Of course, it's only for use enjoyment of the land. Yes.
Yes. So therefore, the pattas issued by the district council in respect of the land belonging to the Nokmas, both the way, my lord, it is not permissible. It is incompetent. Okay. Either it is a Nokma land or it is any other land.
Okay. Yes.
Now, the district council has come up with the argument that they are collecting the revenue and they are allowed to collect revenue as per section 8, paragraph 8 of the 6th schedule to the Constitution of India, my lord. And in this respect, they submitted one judgment of Jantehes Autonomous District Council versus Kuwait. In this judgment, the Honorable Supreme Court had held that the district council can collect taxes or revenue, not the collect taxes and revenue, but only they can collect service charges, provided they render any service.
What's the judgment?
So they said that we can. Judgment was submitted by district council. It is District Council of Joy Autonomous District versus Duet Singh Rimbai.
Yes. You're aware of that case. You place it. Let's see.
No, they are the one which they have placed, my lord. Not it. I am not placing this. It is the district council which has placed the order.
(1986) 4 CC.
Yeah.
In its paragraph 11, that put relying on paragraph 11 and 20, 19 and 21. 19 and 21.
No, more important be that judgment of CT 1775 than this judgment.
Yes, ma'am.
Yes.
They have relied on that in the judgment also. Pretty much. My lord, in their affidavit, also they have accepted the position that it is our district council is governed by citizen service. They are not opposing it, ma'am. It was filed on 5th April 2025, 2023. Where they have admitted the position that citizen service case is applicable.
Yes. Mr. Siddiqui, we feel that
yes,
before we, like you say, embark upon examining the merits of the matter, that you have to satisfy the court
yes,
that this writ will be maintainable in view of the fact that it's challenging a regulation which was passed 72 years ago.
Yes.
There are judgments to that effect. Even of 30 years,
yes,
what happens? Yes. You please satisfy the court first as to why you have come now to make this challenge. That then, if you satisfy this court that yes, questions have arisen and you can satisfy that yes, these are the reasons for which we have not agitated earlier or whatever, and that the cause still survives, then we will look at the matter. But right now, with the merits, we are pretty. I mean, like this is the facts. There's not much. What do you call it? Confusion. Yes.
In that case, let it come after 2 weeks, my lord.
You please bring authorities along these lines.
Yes, my lord. That
yes. So your challenge is
I was a petitioner. Yes. Similar ground.
In that market regulation matter, that was also an old regulation.
Yes.
That was passed.
Yes.
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 Market regulation was upheld, my lord.
Yeah, of course.
That
judgment was by this bench.
Yes.
Yes.
Yes, my lord.
Yes. On the previous Siddiqui to further prepare the matter. This is a matter after. We'll give it 3 weeks.
2 weeks.
Good.
Yes.
Item number 7.
May it please yours. Dr. Saraf has to lead the argument for me.
My lord.
Yes, Dr. Saraf. Where were we?
Well, item number 60, your lordship is dealing with it first.
Number?
60.
Yes, I do see 60 first.
Item 7, my lord. That will be, sorry, item 9. Item 9.
Item number 9, my lord.
Bill to comparison like one photo like what is change कर
Yes, Dr. Sarar.
In fact, in this case, I made an argument. Some AG also replied. I have to only reply.
Yeah, he's made those bullet points which you want to reply to.
Yes, yes.
This argument, he's already made the argument, you know.
He's made arguments. He's given those bullet points which you wanted to reply to. Yes.
Only I want to reply, Milo.
Yes.
Well, the first point which I want to reply is that, Milo, the notice which my learned friend, learned AG was relying on, that was the notice issued in terms of section 47, section 45 of the Act.
MVAT Act.
My lord, if your lordship look to that notice, my lord.
Yes, Dr. Sir.
If your lordship looks into that notice, my lord.
Yes.
You lordship find that notice was in fact a notice for the purpose of making a scrutiny assessment or assessment, which you lordship find at page 19.
1 second.
17 of the affidavit of position below.
Yes. 1 second before we proceed, Mr. Director General, my brother has shown me that in your bullet points at page 7, there's a notification dated 16.
Yes, 16 April 2007.
Yes. Has it? It's not been. You didn't supply a copy of that.
Sorry, my lord. I have a copy and I supplied to Mr. Dr. Saraf also, my lord. I'll place it, my lord. I'll place it.
It's not with us, but
by mistake, my lord, inadvertently, I have the complete copy with me, and I supplied its complete copy yesterday.
You kindly supplied, yes. Yes. The Dr.
Yes,
Saraf.
I'll do that.
Page 19 of the affidavit of position.
17, bro.
19.
17.
17. Yes.
You also find this notice with reference to the subject above. You are hereby the director reminded to produce in the office of the so-and-so the books of accounts before the so-and-so period so-and-so under the Meghalaya Value and Tax Act 2003 for positively failing which assessment for the above period shall be completed on the basis of so-and-so.
That's judgment.
First of all, this was a notice under the Meghalaya Value and Tax Act.
Yes.
And we are concerned in the present case under the Central Sales Tax Act 1956.
Yes. In item 60.
60. Well, item number 9. You know?
Yes, yes. Yes. Yes.
Secondly, here, my lord, the authority has directed for production of the books of account.
Yes.
If your lordship looks into section 45 of the Act,
yes,
there is no provision for direction of for production of the books of account.
Yes. It only provides the best judgment.
It is only a base judgment assessment. There is no provision for production of the books of account. Only when it provides me only that when the authority is not satisfied. The returns submitted were correct and complete. Yes, Your Lordship, once again see me, Lord.
Yes.
Section 45.
Yes.
If no returns are furnished by registered dealer in respect of any period by the prescribed date, or if the commissioner is not satisfied, a commissioner is not satisfied that the returns furnished are correct and complete, the commissioner shall proceed in such manner as may be prescribed to assess to the best of judgment the amount of the tax due so and so, so and so. So the first condition is that if the returns are not satisfied, that is not applicable. Second is that if the commissioner is not satisfied the returns are correct and complete, then he has to proceed for making of the best judgment assessment.
Yes.
Now there is no provision for
examination of book records.
For direction of the books of accounts and documents.
Yes.
Secondly, my lord, the assessment is to be made in such manner as may be prescribed. Base judgment assessment has to be done in such manner as may be prescribed.
Yeah.
Now the manner of making the base judgment assessment had not been prescribed in the rules.
It's under 40. Let me see. Where's this 45? Let's see.
If your lordship looks into my lord by written submission, my lord.
The judgment, yes, 45. In this order. In the, 1 second, Dr. Sarah.
My lord, my lord.
In page 17, the asset production books of 45 piece or something else. After opposition. Yes, yes.
Well, if your lordship looks into my written submissions, page 8, my lord.
Written submissions are here.
My lord. Along with the compilation, my lord. That is the first.
Yes.
Page 8, my lord.
Yes.
Well, I dealt with the no manner prescribed for completion of the base judgment assessment as provided so and so. Section 45 provides for the fulfillment of the preconditions laid down therein. The commissioner shall proceed in such manner as may prescribe to assess the base judgment. The word prescribed has been defined by section so and so to mean prescribed by the rules made under the Act. However, no such manner has been prescribed by the rules to assess to the best of judgment as required in section 45 of the Act. In the absence of manner having been prescribed for completion of the base judgment assessment, the commissioner cannot exercise the power to make the best judgment assessment under Section 45 of the Act. But thereafter, we relied on the judgment of the Guwahati High Court. So while examining the provisions of Section 27(1)(b) of the Assam General Sales Tax Act, which provided for deduction of the tax in the prescribed manner at the prescribed rate, and where the rate and manner were not prescribed by the rules, held that in the absence of the prescribed rate and manner, the respondent authority would have no jurisdiction to issue notice directing for deduction of the tax at source. Well, I reproduced the relevant part. Thereafter, my lord, the rulemaking authority prescribed the rate, but the manner was not prescribed. And thereafter, again at page 9, you will also see, pursuant to the judgment of the Guwahati High Court in so and so, though the rate of deduction was prescribed, but the manner of deduction of the tax source was not prescribed. The Guwahati High Court, therefore, again in so and so, held that as per Section 27(b), some manner regarding the deduction of tax has to be prescribed, and since the same was not done, no deduction of tax at source can be done. Next page, you will also see, page 10.
No, just remember, you have placed this Nazir Ahmed.
Nazir Ahmed, Arjun, and these judgments, you'll also kindly again see, page 1155.
Yes.
Section 55. But it also provided, but the commissioner has reason to believe the detailed scrutiny of the necessity. The commissioner may, notwithstanding the fact the dealer has already been prescribed, Section 50 serve on such dealer in the prescribed manner a notice requiring him to appear on the said date and prescribed within which he may be permitted at such so and so, either to attend or so and so. Thereafter, to give effect to Section 55(1)(d), my lord, the manner was provided for in Rule 36. You will also see 36, best judgment assessment. The appropriate audit authority shall issue a notice to the dealer in Form 22, and the same will contain so and so, mentioned in subsection 1 of Section 55. So in Section 55,
yes,
the manner for best judgment assessment was prescribed in the rules, my lord. But so far as the Section 45 is concerned,
yes, but in the notice that which annexed by them, it does not say under what section. It just says that produce books of account and best judgment. Have you seen that notice? Yes. The affidavit, the state affidavit, that page 17. I don't know, just cursory. That is, it doesn't.
But you'll also see the next, you'll also see the type copy at page 19A.
This is her. This is 15. Yes, what does it say? Production of books of accounts. So, we understand, but then it doesn't say the other 55 under 45.
No, it doesn't say, but you'll also make clear in the 19A.
Yes.
You'll also find that the so and so appeared with the books of account which were verified on 19/10/2021.
No, whether it is under 55 or 45. That's it.
You'll also thereafter see 16 at page 19A.
16?
Page 19A, my lord. Yes. On the left hand side, 30/11/2023.
19A 30/11/23.
My lord, returns scrutinized under Section 39 of the Assam Value Tax Act, Meghalaya Value Tax Act.
Yes.
So and so. So, in pursuance to this return, this notice, the returns were scrutinized under Section 39 of the Act.
Yes.
You know, typo error is there. Animal is written.
Yes, anomaly. Yes. Yes.
We take it anomaly. No problem for it.
Animal may be found also. You don't know. Yes. Yes.
So, my lord, this under Meghalaya Value Tax Act, in pursuance to this notice, the returns were scrutinized under Section 39 of the Act.
Yes.
And these orders under scrutiny and 39 of the Act are subject matter of challenge in WPC 59.
Yes.
So the combined reading of the notice as well as the order it will be clear that this was not a notice under section 45 of the Act.
Yes.
Because 45 of the Act is a precondition is there that the commissioner is of the opinion that the returns filed are not correct and complete.
Right.
Lordship, kindly see 45 2 also, my lord. My learned friend 45.
I will come.
AG,
I will come and place everything. I will not hide anything from the court.
Yes.
So first of all, my lord, my submission is that the preconditions of section 45, first of all, that the commissioner must be satisfied that the returns are not correct and complete.
Does not
then
exist.
He can proceed.
Does not
then
exist.
He can proceed. Doesn't exist. And then he can proceed to make a best judgment assessment. So first, the primary precondition of the satisfaction is not there. Secondly, the best judgment assessment has not been made.
Yes.
Number 3, the manner of prescription of making the best judgment assessment is also not there. Fourthly, this is not a notice for section 45 of the Act. Now my learned AG is saying about section 45(2). You'll also see 45(2), my lord.
Yes.
I will also got it, my lord.
Yes.
Where upon search and seizure of the accounts, registers, documents, or the goods of a dealer registered under the Act, or upon inquiry of the information received from the verification of the returns under subsection 6 of section 35, or where refund of any tax, interest, or penalty arises, the commissioner has reasons to believe that the dealer has not accounted for the turnover of the sales of goods or purchase of the goods appearing in the such accounts, registers, or documents or books of account referred to in subsection 84, or has not shown the turnover in the return furnished in section 35 in respect of the return period, or has furnished incorrect statement of his turnover of the sales or turnover of the purchase of the, or incorrect particulars of his sales and purchases in a return, the commissioner shall, notwithstanding anything contained in subsection 1, proceed in such manner as may prescribe to assess to the best of judgment of the amount of tax payable by the dealer in respect of such return period, after giving the dealer reasonable opportunity of being heard, and direct the so and so. Now here, the condition is that, my lord, first condition, that upon search and seizure of an accounts, that is not there.
Yes.
Second, you'll also find that upon scrutiny of the returns, inquiry or verification of the returns under subsection 6 of section 5, or the refund of so and so, commissioner believes that the return has not accounted for so and so, or the section so and so has not shown to be furnished incorrect particulars, and so and so. Now, here there is no satisfaction arrived at by the commissioner, the reason to believe, before proceeding to make the assessment. No such satisfaction is there. You'll also find that the reason to believe.
Yes.
The commissioner can proceed when the commissioner has a reason to believe of the conditions which are mentioned in the earlier part, then he can proceed to make a best judgment assessment by issuing a notice. Now, in this case, neither there was such a seizure, nor there was any scrutiny notice issued under the Central Sales Tax Act 1956.
Yes.
There was no scrutiny notice. Instead, your Lordship, can you see the order which has been passed? I'll take your Lordship to the one of the first orders, madam. The first order is at page 150, 160 below. 160 below.
Yes. We have gone there before.
Annex 2 below.
And the return submitted and accepted is complete. That's the point you want to make.
Are accepted as complete.
Yes.
So if the returns are accepted to be complete, correct and complete, below.
Yes.
The question of invocation of the powers under section 45 of the Act does not arise.
Yes.
Now, in thereafter, my lord, in subsequent assessment, you also may see at page 173. Prior to that, all it has been said, my lord, that the correct and complete.
Can it be accepted?
Page 170, my lord, page 170 is also cannot.
170, 170, 171 is accepted. 170 is accepted.
Cannot be accepted.
No, it's a 170 accepted. Then 171 also accepted. So 172 cannot be accepted.
The 170 will say cannot be accepted.
170 says cannot be accepted. No.
Yes, my lord.
No.
As the return submitted cannot be accepted is correct.
170. No. Yes.
170 below 711.
In my 170, see.
That is for the period 31/12 to 9.
See, the period here is for
Some paging mismatch is there.
At the top,
period ending serial number 4, 31st December.
Period ending 31/03/14.
Well, that is some.
Then there's some problem with the pagination. See, in my copy, it's for the period ending 31/3/14, where accepted is complete and correct.
You will also see page 173.
Then where is that 09 then? The assessment is 09. 09, right? That is the condition. Yes. It must be here somewhere.
Well, what my submission is that, there are two findings. Well, in some of the periods, the commission.
One second, Dr. Saraf.
My lord, I'm sorry.
Yeah. Yes, this is here. 31, right? This is. Cannot. Yes. And you want to see what? Just see 1 second. We're just trying to correlate the pages. And 153 of my brother's copy shows the. 153 of your copy, Dr. Saraf, in my copy, page 153 contains the assessment period ending 31/12/09, where it says that cannot be accepted. In my copy, 153, page 53. Whereas in your copy, I think 153 is something else.
Well, also looking into the consolidated amended petition.
Yes. What the copy? Oh yes, okay, right. Sorry. Yes, now we got the right copy. Can be accepted, right? Right. Let's proceed. Please proceed. Yes. Conclusion.
Page 170 melody says cannot be accepted.
Yes. Sorry.
So, my lord, there are two types of orders, my lord. In one, the assessing authority has come to conclusion that the returns
Satisfied, or they're not accepting. Yes.
cannot be accepted.
Right.
Now, in respect of those periods where the assessing authority come to the conclusion the returns are complete, Section 45 cannot be invoked at all.
Yeah.
Because Section 45 can be invoked only when the returns are found to be not correct and complete.
Yes.
Now, in respect of the second one, where the authority has come to the conclusion the return cannot be accepted correct and complete, the lordship find that the proceeding for Section 45 can be initiated only after the commissioner has come to the conclusion that the returns are not correct and complete. Thereafter, yes, he has to issue notice for the best judgment assessment in a manner prescribed. This finding of the not correct complete cannot be in the order which is passed in Section 45 of the Act.
Yes.
This is not contemplated by Section 45 of the Act.
Yes.
Like
argued in appeal also, my lord.
Yes.
Mr. AG, why you are so? I am coming. I will also address that point also.
Yes.
That we can.
Let's try to complete. Let's try to complete it as quickly as possible. You got a heavy board today. Yes.
Learned AG has completed. I am only replying.
Yes. Yes.
Not a reply, my lord. It is entirely new arguments, and this was not argued. Their argument was
no, Mr. AG. It was very much argued.
Alone. And even the returns which were filed by them and notices which were not placed before your lordship. It is a completely new argument.
If my lord may kindly see the notings, whether I have referred to these notices, whether these orders, earlier also noting, you will also may see my arguments, and you will also may see my written submissions also, where these points have been addressed or not.
Yes.
If these points were not addressed, then one can say, my lord, that these points were not argued. There is nothing new point, my lord. These are all points which have been.
No, to put it very concisely, where the accounts returns have been accepted, 45 won't come at all. It's only, but the commissioner's come satisfaction. Now, where it can be accepted, the commissioner has to be satisfied that for reasons it can be accepted, and then the other proceeding will come under 45(2), right?
My lord.
Yes.
45(2) only, my lord, after the scrutiny of the returns, my lord.
Yes.
And there was no scrutiny of the returns insofar as the central sales tax assessments are concerned.
The
central sales tax. This is under the Central Sales Tax Act, my lord.
Right.
The notice which my learned friend placed before my lord, that was under the Meghalaya Value Tax Act.
Right.
So there was no notice at all, even if assuming, for the argument's sake, it is taken that that is a notice, then also that is not a notice under the Central Sales Tax Act. Instead, that was a notice under the Meghalaya Value Tax Act, and in pursuance to that, my lord, the scrutiny assessment was completed.
Yes.
Which is subject matter of challenge in WPC 59 for law similar.
Yes.
Now, you also may kindly, in my page 3 of my written submission, I dealt with those points, my lord. Order passed under the purported exercise of powers under Section 45 of the Act have been passed without fulfilling the mandatory preconditions of Section 45 of the Act. Now, my learned friend was saying about notice. You'll also see page 5.
5 of?
of my written submission, Lord. The 5 or 6 lines for the bottom, Lord.
Never ends. Yes.
In the affidavit of opposition, I will also got in, Lord.
Yes.
In the affidavit of opposition submitted by the respondent, it has been submitted. The notice dated so and so was issued to the petitioner before passing of the order on section 45 of the Act. From perusal of the said notice, it is also clear that the said notice was for completion of the assessment under section 55 of the Value-Added Tax Act, and no notice was issued for completion of the assessment under section 45 of the Act.
But this notice was not at all referred in the writ petition, Milord.
I am coming, Mr. AG, I am coming.
Only 2 grounds have been raised, Milord. After I counter everything and then I raise that issue, now they are saying that it is.
You have argued about the suppression. I am coming, Mr. AG. Why you are so much? Generally, in this way, the AG never disturbs. I am never saying that this notice was there part of the writ petition. I am not saying.
Yes.
It takes 2 minutes break, Milord, because once the flow is, Milord, broken.
Milord, it's a not adversarial. We are trying to assist the.
It is adversarial. This is not a PIL. This is adversarial litigation.
So please don't argue against each other. He's big submission to the court. Yes. Yes.
So, Milord.
Yes.
My submission on this point, section 45, I made submission. Now the question which was raised before Lordship about the suppression of the material fact, that this notice was not a part of the writ petition. Now your Lordship is aware suppression of the material facts is such fact which is necessary for the adjudication of the writ petition. If this notice would have been a notice under Central Statistics Act 1956 and under section 45 of the Act, one could have said, well, there was suppression of the material facts. When this notice had no relevance.
Even then, should have alluded to that this notice was received but is of no relevance.
My Lord, if in this way, my Lord, if for any assessment which is challenged the Central Statistics Act, all proceedings under the Meghalaya Value Tax Act are also to be annexed.
Of course, they are being collateral proceedings. Yes.
No, my Lord, Assam Value.
Because adjudication has arrived at wrongly or rightly on the basis of some notice. So that also has to be brought to the notice of the court.
It has not been arrived at on the basis of that notice. That notice culminated in the passing of the scrutiny orders.
Right. So not adjudication, yes, on passing of any orders, that should have been flagged to the court that in it is not a notice under the Central Excise Act, and that is also has no relevance.
Well, that can only be done when the other side says that this is a notice. Well, how I can say that this is not a notice when this is not a notice at all? When the other side relies on and says that this is a notice, then we can reply that this is not a notice. Well, in the pleading so far, I have understood.
Okay, please continue. Yes, that part we are not really satisfied. Anyway, yes.
So, yes. In my humble submission, there was no suppression of any material facts.
Yes.
Which was necessary for the purpose of adjudication of the petition, because we have submitted that there was no notice issued under section 45 of the Central Statistics Act 1956. It is from the department side that when they are saying that this is notice, then we have replied that this is not the notice.
Yes.
So in my humble submission, my Lord, to say that there is suppression of the material, my Lord, I'm sorry, my Lord.
Yes. Please continue. Yes.
Now, my Lord.
Please continue. Yes.
My Lord. Now, the question of the alternate remedy.
Yes.
At page 20 I dealt with, my Lord.
With my learned colleagues' permission, my lord, your lordship's judgment of Jorabat is also I will be placing reliance, so that lordship has held recently, my lord, in Jorabat judgment rendered on 2nd June, where lordship in paragraph 49 and 50. Your lordship has said that it is not a case of violation of principle of natural justice, and your lordship has said that there is an alternative efficacious remedy.
Learned AG, you must know, but first of all, when they placed the judgment, it was incumbent on you to supply a copy in advance. Yesterday night, yesterday up to 10 o'clock, we wanted to give on ringing to you that you have not given the annexures. With much
9 o'clock we have supplied. Whatever is.
Anyway, please keep your differences outside the court. Yes, the thing is that.
The question is that. No, question is that, my lord, when the last time your lordship said that the annexures should be supplied.
See, please, because they're all in virtual mode, so I think maybe it's a bit all getting edgy. But please just let's have some modulation and moderation. And please place an auto remedy, then we'll close the hearing here. Yes.
I'm sorry, my lord.
Yes.
Page 20, my lord, I've dealt with it.
Yes.
Your lordship may see. Our submissions before lordship are that the orders are absolutely without jurisdiction and without fulfillment of the preconditions necessary for invoking the powers in Section 45 of the Act.
Yes.
Now, when the preconditions are not fulfilled and when the orders are challenged to be without jurisdiction, Lord,
yes,
then in my humble submission, relying on the decisions which I have referred to in the para 20, Lord, the writ petition is maintainable.
Right.
Because the latest judgment with the Godrej Sarali Mirror, I have given the judgment copy also.
Yes.
Where it was said that since a jurisdictional issue was raised by the petitioner writ petition questioning the very competence authority to exercise the summatory power, being a pure question of law, the plea raised in the petition deserved consideration on merits, and the appellate petition ought not to have been thrown out of the threshold.
Yes.
So, my submission for lordship is that the appeal will not come in the way.
Understood, sir. Yes. Now, your submission hinges on Section 45. There was no instance, there's no occasion to invoke it, and the way it's been invoked is absolutely contrary to law. And so the notice is without any jurisdiction, and so the assumption of jurisdiction under MV80 is wrong, and as such that is a pure question of law. That's all. Yes.
And the CST was wrong. Now, one argument was advanced, my lord, about the time limit, my lord, that there was no time limit for completion of the assessment under Section 45 of the Act in the statute.
Yes. Now you're trying to say that analogy may be given from other taxing statutes or other provisions that it should be 7 years or 5 years. Correct?
5 years, my lord.
5 years.
Assessment, audit assessment.
Yes, audit assessment.
And for reassessment also. Your lordship is aware, my lord. Your lordship remembers everything. My lord, I'm really unnecessarily troubling your lordship for the purpose. Your lordship remembers everything. But I've given the two judgments.
No, I don't remember anything, Dr. Saraf. Yes.
My lord, now, what your lordship observed, my lord, it is the crux what I was arguing for lordship. Two judgments I've referred to, my lord, of the Supreme Court in compliance, my lord, in that connection, my lord, where the Supreme Court said that when the total time limit is prescribed, the assessment or order must be passed within a reasonable period, and the reasonable period has to be determined on the basis of the scheme of the Act. And the apex court said that when the 3 years was the limit for ultimate limit, that will be considered to be the period of limitation in provisions where there is no time limit is prescribed.
Yes.
Now, Milord, I will just 2 lines I will reply, Milord.
Yes.
One, my learned AG argued, Milord, that even if the time limit is not prescribed, then the assessment can be completed at any time. That I have already dealt with, Milord. And secondly, Milord, the learned AG argued that even if the manner is not prescribed, the assessment can be made on the basis of the provisions of the Act itself. Now, Milord, my humble submission, when the provisions of the Act itself provides that it has to be done in a prescribed manner of making the best judgment assignment. If the best judgment manner has not been prescribed, the section provision of the Act cannot be given effect.
Yes.
Rest, I rely on my written submissions, which can be filed before your lordship.
Thank you. Yes.
This is my humble submission.
And Dr. Mr. Attorney General, any other submissions?
Yes,
We
I've
wanted to
got
place
I've got the printout, my lord. My colleague is having, so kindly of the annexes, my lord, attached to my written arguments, my lord.
Yes. And the other judgment you want to rely upon?
Yes, my lord, those judgments are also compiled and compilation was given, my lord. I will give it, all judgments are referred in my written note. It will
An alternate remedy also you have to give Dr. Saraf the,
yes, sir,
you know, the benefit of
of
examining
the Jorabat judgment, my lord, your lordship judgment in Jorabat. We'll file it, my lord. During the course of the day or by tomorrow, my lord, we'll do it.
Yes. So we'll close the matter then.
My
Yes,
lord,
my lord.
Yes.
there are so many judgments on alternate remedy. There is no dispute about those.
Yes.
The lordship has referred extensively to all judgments in your lordship's judgment rendered on 2nd June, my lord.
Yes. Heard the hearing is concluded. Reserved for judgment.
This will cover, my lord, two.
Very disturbing. Yes.
Copy has also been supplied to the side.
Yes.
I to one and section 39 to law print of the problem.
Yes.
Item number 9 below.
Yes. 9.
7, 8, 9, it will cover item 7, 8, 9. My lord, because item 9 is item 60, my lord.
Yes.
8 is 59, and
No.
7 is 40.
8 we have to add.
1 second.
Listen here.
See, this is 60 is item number 9 we had just now. Yes.
Yes. 60 was being referred to by.
Yes. 59
by letter.
7 is Dr. Mozika is the petitioner.
In item number 7, I'm there, Lordship.
Yes. Yes.
Your Lordship. Your Lordship, in item number 7, we're relying the submissions of Dr. Saraf, Lordship.
It's identical.
Lordship.
Suppression, everything is same, my lord. Everything is same.
In 7 also.
Lordship.
Yes, 7 also.
Yes, the same order. 7, 8, 9 is. Yeah.
7, 8, 9, my lord, all three will be reserved.
Yes.
Then
8 my lord.
Yes. No, sorry, matters are over.
My lord.
No, your matters are over. 7, 8, 9, we reserve all of them for judgment.
8 my lord is a different my lord. 8
10?
is different, which you lordship argued. I argued earlier, and the judgment was reserved. Your lordship again posted it, my lord.
No, that's covered. That is item number 8, I think. 8, yes.
8.
Yes.
That is relating to section 39 of the Act, my lord.
That's different.
That is different.
Oh, 7 and 9 are same.
My lord.
7 and 9 are the same.
This matter was earlier heard and reserved.
No, sir, yes, because we thought we'll pass it together, but the matter could not be. You could not conclude other matters. That's why we release it from CEV. Number 8. What's the difference? What's the difference in number 8?
Number 8 is, my lord,
order passed after 39 and 45, my lord. And in 8, my lord, it says stage at 39, notice is challenged, my lord.
Yes, you want to place arguments?
Yes. I want to just refresh. It was argued written submissions have been filed. Your lordship is section 39.
We have also filed written submission, my lord, combined written submission in all three matters together.
Right.
And earlier also we have.
Yes. Yes. Yes.
My lord, you also may seek section 39, my lord, at page 15 of my writ petition.
Yeah. Page
15 me.
15.
1-5 of the consolidated, my lord.
Right, right. Yes, please.
May I read, my lord, both first paragraph, my lord. Each and every return in relation to any tax period furnished by a registered dealer to whom notice has been issued by the commissioner under section 35 shall be subject to the scrutiny by the assessing authority. So, my lord, in respect of the returns furnished by the dealer to whom a notice has been issued by the commissioner under section 35 of the Act,
yes,
are subject to scrutiny. Now, section 35 is, you'll also find at page 13.
Yes.
Subsection 3, you'll also see.
Yes, any dealer other than registered dealer.
Referred to in subsection 2, shall, if so required by the commissioner by a notice served in the prescribed manner, furnish the returns in accordance with so and so. So, a dealer, in respect of the return period to whom a notice has been issued under section 35 of the Act, are subject to the scrutiny under section 39 of the Act.
Yes.
Here, it is admitted fact that section 35 notice was not issued by the commissioner.
Okay.
If section 35 notice was not issued, my lord, then the passing of the order on section 39 of the Act is actually illegal and without fulfillment of the preconditions, and is actually without jurisdiction.
Where's the notice?
Notice on the 35 is not there, my lord.
It's not there at all. Yes.
No, this is also admitted that 35 notice is not there.
Yes.
I dealt with in the same, my lord, in page 1, and at page 3 of the written submission, you'll also kindly see, my lord.
Yes.
Second paragraph,
Tripura judgment.
My lord.
Yes.
Just one paragraph, if you'll also permit me, I may read, my lord.
Please, please. Yes.
The reliance he placed on the judgment of the Tripura, judgment of Division Bench of Tripura High Court, wherein while examining the parametry provision of section 27 of the Tripura Value Tax Act, the Tripura High Court held the power under section 27 can be exercised only in relation to a dealer to whom notice has been issued by the commissioner under section 24 of the Act. The Tripura High Court held that unless and until such a notice is issued in terms of section 22 or 224 of the Act, the authority cannot invoke the powers under section 27 of the Act. Now, Lordship may see page 18. I just see the section, Lord. What is the section? The relevant part of page 23, Lord.
Yes.
Let me see paragraph 12, Lord. Each and every return, section 27, scrutiny of the returns, bro, the same.
Yes.
Each and every return in relation to any tax period furnished by a registered dealer to whom a notice has been issued by the commissioner under section 24 shall be subject to the scrutiny of the assessing authority to verify so and so.
24 is equivalent to 35.
35. And 24 is also quoted, my lord, at paragraph 10, my lord.
Yes. Oh, yes.
And the relevant part at page 23, subsection 2, my lord.
Yes.
If the commissioner has reason to believe that turnover and sales have exceeded the taxable limit so and so, he may by notice served in prescribed manner require dealer to furnish a return so and so. Lordship, kindly see page 26, my lord. 25, my lord.
Yes.
Paragraph 17, my lord.
Yes.
Section 27 of the Act relates to scrutiny returns. Section 1 of Section 21 provides that every return in relation to the tax period furnished by the registered dealer to whom a notice has been issued by the Commissioner, Section 25 shall be subject to scrutiny by assessing authority to verify the correctness of the calculation, application of the correct rate of tax and interest and input tax credit claimed therein, and full payment of tax and interest payable by the dealer during such period. Section 2 of Section 27 provides that if a mistake detected as a result of the scrutiny, the Commissioner shall serve a notice in the prescribed form to the dealer to make the payment of the extra amount of tax so and so. Section 27 of the Act is thus not a provision for full assessment of the return filed in response to the notice issued by the Commissioner under Section 2 of Section 24 of the Act. It is merely a purpose of verifying the correctness or necessary details furnished by such dealer as calculation, application rate of tax so and so. 19. The provisions contained in Section 27 of the Act are vastly different from the provisions contained self-assessment under Section 29, provisional assessment Section 30, and most significantly audit assessment under Section 31 of the Act. The special power can be exercised only in relation to a dealer to whom notice is issued by the Commissioner under Section 24 of the Act. Section 24 refers to a notice only under Section 2 of the Act. Necessarily, therefore, unless and until a notice is issued in terms of Section 2 of Section 24 of the Act, authority cannot invoke the powers under Section 27 of the Act. Any other view would defeat the very scheme of the said chapter providing for the audit assessment and the limitation for completing such assessment as provided under Section 33 of the Act. The respondent authority cannot be allowed to circumvent the limitation provision for completing audit assessment by permitting resort to the powers of summary adjustment under Section 27, which are peculiar in nature and are available only in cases where the subsection 2 notice has been issued. Thus, so and so the improvement orders are passed. Below here, the court has dealt with both the issues below, the issue of limitation, as well as the preconditions for the exercise of the powers under Section 39, which is equivalent to Section 27 of the Act.
Yes.
Now, the submissions in the written submission, my lord, in the affidavit.
Yes.
Again, they have referred to about Section 20, the notice under Section 20 of 27(4). In my humble submission, that notice cannot be issued at all because there was no notice issued by the Commissioner of Taxes under Section 35 of the Act. Now, you will also kindly see, my lord, the time limit that I have already submitted for lordship, my lord. Now, section page 11, my lord.
No, your compilation with judgment page.
Page 11, my lord.
Oh, your compilation.
My lord.
Yes, what do you want to show by page 11? Not being delegated.
I want to say, my lord, the delegation notification which has been placed by the learned AG, Section 39 is not there.
We have not had occasion to look at the notification. Because
Well, that was enough. Your Lordship may check up, my lord, whether the notification 39 is there or not. If the notification says about 39, then this argument will not be there, but I have verified section 39 is not there.
Connection थे क्या bullet points no not here sometimes I to buy happy and say I be looking that is not getting I will take a joke but yes. Yes, inside parts of something. Yeah, so it's not there. 39 is not there.
39 not there, bro.
Right. Right.
Now, coming to the alternate remedy, bro, there is no appeal provided for against an order passed in section 39 of the Act.
Yes.
Secondly, my lord, I have relied upon again the judgments of the apex court, the jurisdictional issue, and the preconditions I have referred to, my lord, in my lord.
Page. You compile it, yeah?
Yes, my lord. Page 13, my lord.
No, not 13. I mean, where are the judgment annexed? You annexed it in a compilation.
Yes, yes. All
yes,
these
yes. You kindly give the page. Which is the judgment?
Well, page 13, I have relied on the judgment of case Subramaniam, which you'll also find at page. I'm just 1 minute. This is Subramaniam. At page 174.
Yes.
186. 212. 218 and 236.
You made same assumption. Yes. Okay. Anything else?
Well, at page 15, you also see one submission was advanced by the AG.
Yes.
Page 15.
Yes.
Submission of the respondents to read down the provisions of section 39 of the Meghalaya Act.
Yes.
Yes, but petitioner in the petition has not challenged the validity of section 39 of the Act. The validity of section 39 of the Act not being challenged, the respondents cannot make a prayer to read down the provision section 39 of the Act so that the order passed by the authority may come within the purview of section 39 of the Act. The apex court in so clearly held that in the grave of reading down the provision, it is not open to read words and expression not found in the provision or statute and thus venture into the kind of judicial legislation. The Constitution bench of the apex court in Payas also held that the doctrine of reading down of the recasting the statute can be applied in limited situations, and the same is essentially used firstly for saving a statute from being struck down on the ground of unconstitutionality. The apex court held that it is not possible for the court to remake the statute, and it is only in the strike down and leave it legislature to be amending it. The apex court held that the doctrine can never be called into play when the statute requires extensive additions and deletions and is not undertake to exercise it, but to beyond the jurisdiction to do so. Paragraph 7 is reproduced below. Here, my lord, the word to whom the notice has been issued by the Commissioner under Section 35 of the Act, the learned AG's argued, my lord, that may be read down.
Yes.
When the constitutionality of the Section 39 of the Act is not under challenge,
Yes.
but the question of the reading down the provisions of the Act does not arise.
Yes.
And in any case, when the statute clearly says, my lord, that the condition that the scrutiny can be done only in cases where the notice has been issued by the Commissioner under Section 35 of the Act, my lord, the question of reading down the same is not in any way unconstitutional, and the question of reading down the same does not arise. Reading down will arise only when the provision becomes unconstitutional, and lordship, my lord, in order to save the provision from being unconstitutional, did sit down. But in this case, neither there is a challenge to the constitutionality of the provision, nor the provision is unconstitutional.
Yes.
The precondition is there, and the precondition has not been fulfilled. Thereby, the order is illegal without jurisdiction.
Anything else?
And the limitation question, the same is there.
5 years.
Argued, 5 years, and that I have given in the written submissions also.
Right.
Although 5 years has not been prescribed, but it has to be done with a reasonable period, and the reasonable period has to be determined on the basis of the scheme of the Act.
May it please your lordship. Your lordship, kindly take up my written submission, my lord, of 15th September 2025, 15th September 2025, my lord, in this matter, my lord.
Yes.
Lordship will notice my first point at page 1, my lord, in the bold in the middle of the page, at the foot of the page, in fact, just before paragraph 3. The lordship has my written arguments, my lord.
Yes.
I'll take your now. In re, writ petition is liable to be dismissed on account of suppression of material facts. My first point, my lord, following document facts have been suppressed which are relevant for the relief claimed in the instant writ petition. Liable to dismiss suppression, petitioner is guilty of now, my lordship, kindly turn over the page and next page, my lord. It is submitted that notice was served upon petitioner to produce the books of account way back on 27th April 2017 at page 12 and except 1 of the counter affidavit response number 3 in writ petition number 59 by Superintendent of Taxes under MVAT Act 2003. White said notice petitioner was directed to produce, sell and purchase register, list of tax invoices, cash books, ledgers and stock register, details of exempted goods for the period from 1st of May 2005 to yeah, Lord, I'm sorry.
No, my brother should have the left side. This one. 60.
My colleague can hand over extra copy. My colleague will be having. Lordship, Justice Bhattacharya, want the copy of the written arguments? Mr. Sinpon, you have a copy. You can.
I will get it supplied. Now we have already supplied last time.
Mix up another file.
It's 60, 59 copy. It must be in 60.
No, this is 459 specific.
But in the top, it is written
2025. This is the date on which written submission is dated 15 September in WPC 59 of 2024.
Yes. I have it.
Probably.
We get it.
You know,
common is it?
My lord, in fact, your lordship may find it in 60, my lord, because this is a common, my lord.
No, 59 is a separate when matter was reserved.
Separate, yes. 402 and 60 together.
402
and 68 together.
And 59.
59 is a different. 59 is a separate submission.
Yes.
But
Is to print a copy more, my lord. We'll supply, my lord. If your lordship kindly have this 59 written submission, my lord.
Yes. No, I have it.
Yes, your lordship can share. In the meantime, I have asked my colleague to get it print.
We have not been supplied the copy of 59 separately. After judgment, we have no copy has been supplied.
It was filed along with, and now.
Then you supplied, we'll post this on Tuesday. Yes.
Yes. We'll
59 segregate post on Tuesday. Yes, for further hearing.
Yes.
Yes, yes.
Give a soft copy. We are sending just now.
No, we'll have on Tuesday. It's coming Tuesday.
Yes, sir.
9. Otherwise, we just. Huh? Oh, there's too many papers. Just hold it up.
No, there is another one matter that might be also on Tuesday or some other day.
Which one?
Item number 12.
Number 12.
Dalmia Cement, my lord.
Okay, 12, yes, Tuesday.
Tuesday or some other date. Tuesday will be on that 59, we argue.
Yes, okay, we'll have another date. 12, we'll have it after 2 weeks, yes.
After 2 weeks,
Yes. Call up 10.
I'm highly obliged.
10.
Yes. Signora. Instructions received. Where's Mr. Deb?
Mr. Day will appear through BC, Your Lordship.
We can't see him. Yes, Mr.
My
Deb.
lord.
Yes.
My
What
lord, in
instructions
this
are
matter-
received? Yes.
No, I'm yet to receive the instruction. They have yet to place this matter before the EC, my lord. Mr. Sangma has given me a letter, my lord, a copy of the representation that he has made. I have already forwarded it, my lord. So I will like to take another 2 weeks time, my lord, to get the instruction so that we can dispose it off, my lord.
On the prayer, Mr. S. Dave submits that instructions are yet to be obtained. Less after 2 weeks.
Hello, bless me.
11.
Please, Your Lordship.
You file appeal.
Appeal, my lord, hearing is concluded in this matter, and we are filing our written submissions, my
No,
lord.
but it's not for the last time.
We have already.
No, no.
Our humble submission, we have addressed this in our written argument submissions as well. That
No.
because time is already there for them to file the appeal. my
Yes,
lord.
it will consider Ghati. This is the.
Yes. We have already brought it on.
It's on record. Mr. Fukun last time said that.
Yes, my lord. Our submission, humble submission, is that my lord, creation of a tribunal will not bar our writ petition because it was filed in 2024. The tribunal was constituted in January this year, my lord. Alternative remedy is already there.
Let's tell Mr. Fukun to come and argue this point. Yes. No shortcut. Yes. In view of the order dated 7/5/2026, whereby this court observed that question as to whether the court shall proceed in considering the matter 226 is yet to be satisfied by the petitioner. When you want it, this is a question we posed last time, and so we trying to shortcut the process by just submitting the submissions. If the matter can be taken 226 or not. Yes.
My lord may have it after 10th of July, my lord.
Whatever. Listen.
In that case, may I pray that the interim order which was passed earlier may kindly be extended, my lord. There is an
We'll give
apprehension.
it that much, yes. Interim order be extended till next day. Very easy to dismiss the case right now. We can do without looking at the submission. See that since the IT tribunal is already there, so you go there, finish. You don't have to do that.
My lord, I'll take instructions.
Any mention?
May I please your lordship, I beg to mention item number 33 and 34, both are connected matters.
Other side home. Yes, MSc Jalaya there. 33, 34?
Yes, Your Lordship.
Yes.
No objection, Your Lordship.
Yes. Yes, do it, yes.
Highly obliged.
May please lordship. Lordship, I beg to mention item number 41, my lord. I have informed to the private respondent also to GHATC also. This is regarding the
Employer respondent 4, 5 and 6.
Willard Marak.
lordship. 41.
Yes.
No objection, Lordship.
Yes.
Respondent 1 to 3, Lordship.
Must press lordship.
Hello, Lordship.
My lord, item 48. 48, my lord. Item 48, my lord. Arzina Begum, my lord. The petitioner counsel is from Guwahati and I'm for the respondent. He informed me that he will some difficulty and we are also in...
This Mr. Jalan? No.
No,
No, Lordship.
No.
Different matter, Lordship.
No, my lord. Well, after
Yes,
2
yes.
weeks. And 49, my lord. Item 49, my lord.
Hasina Khatun.
My lord.
What other side?
My lord. Ma'am.
What? Why you don't?
Ma'am, it's the other side.
Yes. No objection.
No objection, my lord.
After 2 weeks. Deeply obliged.
Much obliged, Lordship.
Lordship, I am for item number 35 for the respondent number 2.
Yes.
We have taken consent from the other side, Lordship.
35 is which matter?
For respondent number 1.
And for the petitioner, Your Lordship. No
You haven't
objection.
done objection.
No objection, Your Lordship. No objection, Your Lordship.
Yes, after 2 weeks.
Obliged, Lordship.
Much obliged, Your Lordship.
Yes.
Supplementary list item number 1.
This is a prayer for release of the retirement benefits from the MTC. I may be granted 10 days time to obtain instructions.
Lordship.
Obligement.
Must press lordship.
Issue notice already 10 days.
2.
Yes.
There's a caveat, my lord, in this case.
Who's the caveat?
Lordship, I'm the character respondent number 6, Lordship.
Very good. Yes, sir. Caveat. MS ML Klaus present on behalf of the caveat. You are name the caveat. Rababul Haq.
Yes.
Arish Alice.
Alice Phillips, Lordship.
The lawyer only.
Yes, yes, my lord.
Yes. Who has been arraigned as respondent number
6, my lord.
6. Caveat stands as charge. Yes.
Lord, we are challenging this impugn order that is at page 23, my lord.
23.
Yes, my lord. This order dated 25th May 2026, by which I am debarred from contesting this election of VC election, my lord, in Sobri Bari village.
What ground was here for you?
Ground, my lord, that my husband, who was the then secretary, my lord, there's some allegation of misappropriation of funds by him.
Who is this? Azizur Rahman?
Yes, yes, my lord.
Yes.
In fact, when prior to this, my lord, there are various litigation before this honorable court, if this court recollect, my lord, regarding the election of VC. So there was allegation that some people name were included whose name should not have been there.
Remember, if you're
Yes,
the
yes.
caveat, that lawyer's name
Yes.
was good as a job card holder also.
Yes.
Yes, Lordship.
So
in that case, Lordship, I have filed a complaint.
Yes.
Complaint dated 15 May 2000.
Against the petition also.
yes. So after that, my lord has directed an inquiry, my lord. So one of the findings was there was a misappropriation of funds by the then secretary, my lord. So and as per that inquiry report, they have recommended that the action should be disciplinary action should be taken against the then secretary, and that the wife, the spouses should be debarred. So on that basis, my lord, this order has been passed, in which the election now has been notified, my lord. Election will be held, and it will be held on the 15th of June, Nomination will be on the 8th and 9th of June, and I have been debarred, my lord.
Lordship,
And this inquiry, my lord, I have not been made a party.
No, see this is therefore in terms of maintaining transparency, integrity. This is page 23, right?
Yes, yes,
and
my lord.
Fairness in the Village Employment Council. See Arzur Rahman and his immediate spouse.
Yes, my lord.
Are hereby barred disqualified
Yes,
from contesting.
So how can I be penalized, my lord, for?
Yes, what is the reason for?
May it please your lordship. Lordship, kindly have page 17, 18, your lordship. That is the order passed by this court, your lordship, in the series of litigation, your lord. Lordship, kindly have.
Yes.
Lordship, kindly have page 18, your lordship.
Yes.
These are the submission. Then lordship, kindly have 19, paragraph 5.
Yes.
On behalf of the respondent number 7, that is the husband of the writ petitioner, your lordship, the ex-secretary of the BSc, Mr. So-and-so, submit that in view of the inquiry report, he prayed that he may be allowed to take recourse to appellate remedy as provided in the scheme. Lordship will kindly see what is the date of the inquiry. Lordship, kindly turn to page 26.
No, now he's come for his wife.
Yes,
lordship. Lordship, I'm coming to that, your lordship. Lordship, when did the state file this inquiry, your lordship? Lordship, at page 25.
Yes.
October 25, your lordship.
Yes.
And lordship, kindly have page 30. Disciplinary action.
Yes.
Initiate departmental unnecessary action against ex-secretary, lordship. So, your lordship, as on October 2025, the petitioner is aware, your lordship. Only when this the so-called impugn or notice, your lordship, calling the election, they are aware, your lordship, and approach this. It's too late. In my humble and respectful submission, your lordship, it's too late on the day, your lordship.
She's
Yes,
never.
MS Cloud, what do you have to say?
Lordship, as far as the judgment order dated passed by this honorable court, I was allowed to file a complaint against the respondent number 5.
Where is that complaint?
Lordship, here is the complaint which I have filed, which has been suppressed by the learned counsel. I would like to put it before the court.
Then you file by affidavit.
No, the
Lordship,
copy was never
Lordship, here I just
never
want-
supplied to us, my lord.
Lordship, here, which I want to point it out is that, Lordship, in this
Just a minute.
complaint dated 15 May 2026,
This is the one. This is the one you file. This is the one. 14.
Yes.
Lordship, in that complaint, if lordship kindly have paragraph 5 of that complaint filed by the R7 by my friend R6, your lordship, Mr. Alice. Lordship kindly have at para 7 internal page 3.
Yes.
Lordship kindly see.
Anyway, so since it's not on record as yet. Yes, I've heard Mr. Jeshila, learned counsel petitioner. You should
and Lordship,
notice.
according to Section 5 of the Meghalaya Employment Rule,
You should notice
the
stuff.
complaint should be disposed within 7 days. But if they have filed their petition before the
My lord, so far as
7
Mr. Alice is concerned, my lord, he's not a job card holder, firstly, my lord. Secondly,
That is made that he's
Lordship, in the rule it is
and-
mentioned
and
any
second-
person
and
can
secondly,
file
my
a
lord-
complaint.
Yes,
It is
yes,
not specified.
we've heard,
Any
we've
person
heard,
can
yes.
file a
Heard
complaint.
Mr.
It
Jeshila,
is
like
not
counsel
mentioned that
petitioner,
the
you
job
should
card
notice
holder can file a complaint.
Mr. Ndishla Leonard EAG
Respondent number.
also is present on behalf of the response 1 to 5.
Respondent number 1 to 5, your lordship. Yes.
ML Cloud is present, and ML Cloud for capital is
Lordship, in my
present. Stop.
complaint, I has mentioned that Miss
Yes, you just hear the order. Yes, the complaint, the incident petition is that the petitioner, who stated to be the wife of the ex-secretary of Sobri Bari VEC, has been barred from tendering her candidacy for the elections, which is scheduled to be held on 15/6/2026. Stop. Mr. J. Shalla, next parallel counsel, has submitted that the petitioner is no way implicated in any manner with any earlier proceeding, but for reasons best known to the respondents by the impugned order dated
25 May 2026.
25/5/2026, she has been debarred from taking part in the election. He therefore prays that as the elections are due on 15th and nominations are to be filed by
8 and 9.
8 and 9, that the petitioner be allowed to contest the same. Yes, stop. Next paragraph, Mr. Indishwell EAG, then it counts on behalf of the respondents 1, 2,
5, Your Lordship.
1, 5. Has at the outset submitted. I have submitted that this is that the incident matter has also received the intention of this court by way of writ petitions, where an inquiry report had been generated into the BEC of February. In this context, the learned AG has drawn attention of the court to the inquiry report
dated October,
which was conducted in compliance with the order of this court.
Lordship, yes.
23/4/2006.
And annexed at Annexure 5 to the petition.
Lordship, yes.
He then submits that
page 30, Your Lordship.
And in the findings, in the paragraph contain the findings under the caption disciplinary action. It has been clearly stated that the petitioner, who is the immediate spouse of the petitioner, was to be barred for future election. Submits that this inquiry report was submitted as far back, this inquiry report is dated 16/9/2025, and the petitioner had ample opportunity to assail the same before appropriate authority, but instead has chosen the 11th hour to come approach this court. Ms. Emil Clow, appearing for the respondent number 6, has further submitted that further complaints have been made which have been suppressed in the petition, wherein certain allegations have been made against the petitioner which still mean pending consideration.
Yes. And no copy has been supplied to us.
Go to some that shall be on hearing the counsel of the parties, be that it may, as a matter as it is seen on the face of the record itself, that in the inquiry report dated 16/9/2025, the finding had been arrived at barring the petitioner no relief, the representative had no relief, and the petition stands dismissed. Yes.
Highly apply, Your Lordship.
Item number 3.
Lord, there's a delay in filing the appeal.
For this matrimonial matter, no?
No, my lord, this is succession of the pension benefits. 12 days delay, my lord, so notice will have to be issued to the sole respondent.
Yes, so that will be the synopsis. You can see the first line of synopsis.
Apologies, my lord.
Correct it.
My lord, I'll do that.
Yes, in this case, but Sonso issue notice that on the in this case, number 1 on the plea for condemnation in preferring the connected civil. Why is saying civil appeal? There's even the cause title in the miss case also. Even by civil appeal.
My lord. Just make the corrections, my lord.
Make a correction then.
Yes, my lord.
Mr. Pilaman now please submit the due to certain defects in the cause title, maybe typographical errors in the cause title. We're going to correct the same both in the miss case and the main case. Prayers allowed. Yes, when?
Next week.
Next week, yes. Corrected?
Yes, my lord. Deep to that.
4.
Let's go from other bench. You've verified.
Yes.
That appeared for this person long time ago, maybe. Yes. This is a matter of any other bench without me.
Here, play. 5.
Yes.
Wait, please, Your Lordship.
Where's Mr. Khalindo?
Mr. Shalla is here today, Your Lordship.
Lord, I appear for
Respondent number 10.
respondent number 10, my lord.
Who's respondent number 1?
Respondent number 1, actually, they've received copy, but Mr. Karlingdo said he has no instructions, my lord.
Yes.
So, my lord,
Do you have any objections to extension?
No, no.
Yes, third so for the legal counsel for the applicant. Stop. The other parties today have submitted that they have no objection to the extension raised by the petitioner, by the applicant. Accordingly, the time for compliance orders is extended by another 2 months.
2 months, my lord.
2 months.
Much obliged, lordship. 6.
Is allowed in disposal.
Lordship.
Yes. Yes. None appears for the applicant this up to 1 week. Yes.
7.
My lord,
You filed?
I have filed an affidavit.
No, where's Ms. Shangriso? Have you filed?
My
You
lord,
filed it?
I filed. My lord, only one thing, your lordship. I feel, my lord, to point out to your lordships, only one thing before my learned, subject to what your lordship say. My lord, I feel, my lord, considering this case, other case also started the hearing. I feel, my lord, it may not be appropriate for this court, my lord, to take up this matter. Why, my lord?
Yeah.
The same issue, because there the argument continued for 2 hours, your lordship. Same issue.
Yeah, you can do for 2 minutes. Doesn't matter.
No, they are other court.
My cause is separate, my lord. My cause is separate.
Lord, what I want to convey, your lordships, the issue involved in this case, my lord, also the ditto, the same issue, my lord, citing the same provision involved in the case from which my lord has recused. So, in that circumstances, I feel, my lord, it may not be.
My cause is separate.
See, it's very difficult then.
Same thing, my lord. Otherwise,
my writ petition is before in time, my lord.
It's matter.
What happened? I am a party there.
Before in time, my lord.
I am a party there. My appointment has been challenged only on the ground that Deputy CM, this is the contention here, Deputy CM should have been made the acting CM, because
See,
this is.
Mr. Sen, if you look at cold facts and the law,
lordship.
If an order is illegal or is without any jurisdiction, it should not stand for 1 minute. No matter what consequential, thing. 1 minute also should not be allowed to remain. That is what.
What happened?
Prima facie, that's why this court give you opportunity.
Lordship.
And prima facie, this court already satisfied that yes. I mean so that is the thing. So if you
other
have
thing,
other compelling reasons, yeah, but then
it has come to my light, my lord. With that, almost a hearing tomorrow for final disposal, both for mistake. Ditto same issue.
Happen on Monday.
It was argued for, my lord.
My lord, my cause is totally different.
Different Monday.
That case is dealing with the horse. I'm dealing with the cart, my lord. I have nothing to do with the suspension.
And my affidavit.
Mine is.
But you see, anyway, we'll not make any observations. Let's be taken.
But it's only a law point, my lord, involved here. I'll just point out a few judgments.
We already have examined that. And
yes,
yes. But view the fact that he wanted to give them a fair chance to represent, but then they don't seem to have any other.
No, they have already filed the reply.
Yes.
I have pointed out, my lord, the issue is a ditto same.
I don't require to file a rejoinder.
Pleadings are complete. Disposal in the other court tomorrow, your
lord. I am on a separate cause. My writ petition is before in time, my lord.
So, my lord, if lordship want to defer it till Monday, okay, I think tomorrow it will be concluded.
My lords,
has to be concluded.
My lords don't want. You want it.
My lord, obviously, this is
which I am objecting.
No, this is the thing. This is ditto same, your lordships. Otherwise, what will happen?
It's not ditto.
Findings.
Why Mr. Sen did not place the order of this court then? Yesterday, you said that
I'll place it.
You made the submission there that this matter is pending. But then when the matter is taken up, the other connected matter, you don't say that this matter is pending here or that any orders have been passed.
But I'll place it. We'll place it tomorrow. We'll place it course of hearing. Substantially hearing is
to avoid any complications,
my lord,
or any assertions or apprehensions. Yes,
because my lord, I'm not a party in that matter.
We understand. This is a matter on Monday on the prayer of Mr. SN, who submits that. What's his submission?
My submission, the issue is ditto same, which is coming up
for on the cart. Yes,
coming up for hearing.
That's his submission. Sorry. So let it come on Monday.
The issue there is the horse, my lord. Here is the cart. Deeply.
Daily, item number 1.
Yes, it's for the respondent.
Please.
Yes.
This is the petition under section 11 seeking the appointment of the arbitrator. Well, it's primarily they have just raised two grounds. One is that respondent number
Where's
2.
the ground? Where was the affidavit? Why? When was the notice sent for appointing arbitrator? When you sought for appointment, where is that? The first, when was it?
That is at 27th of January 2025. Page, I'll just. This is, well, it's page 44.
Okay. That was 27th of January.
Yes, please.
27 or 25, okay. Right. Yes.
And at page 48 is the reply below, in which they objected to the execution of the agreement, saying that a different draft was shared and subsequently they signed a different agreement. But in principle, they have admitted the execution of the agreement.
Where's the arbitration clause in the MOU?
I'll just. It's page 30 of the petition. Clause 7. If I may read out my notes. Any dispute or difference arising out of or in relation to this MOU shall be at first instance settled expeditiously and fairly by the parties hereto. In the event that the parties are not being able to resolve the same within 30 days of a written request by any disputing party to call a meeting, where attempt has been made in good faith to resolve the dispute, the matter shall be finally decided by the arbitration. The arbitration shall be conducted by the sole arbitrator mutually agreed between the parties, failing which an arbitrator shall be appointed in accordance with the Arbitration Conciliation Act. Well,
they're signatories to this. You don't deny this, that is signatories MOU, correct?
No, my lord, I have some points to be argued, my lord, on that.
So whatever points you have here, you can take for the arbitrator.
My lord, here
11.6 application.
My lord,
and if you have any dispute, then that you can.
We have not disputed.
You can make it terms of reference for the arbitrator.
My lord, I have not disputed in the transaction, my lord.
You have not?
I have not disputed the transaction. Dispute arises from their side, my lord.
Exactly. What both parties are dispute can come from one side.
My lord. My lord, I may be allowed to submit, my lord.
Yes, please.
My lord, arbitration as per the 11, my lord, which has to be invoked when there is a condition or agreement terms is there.
Yes.
There is a arbitration agreement term is there.
Yes.
As per 7, as my learned friend has mentioned, my lord. My lord, there it has been stated as a condition that one person, agreed person should give in writing to appoint the arbitrator, my lord. I may be allowed to read, my lord.
But the page 44, does it say?
That's that letter which has been clarified, my lord. That is a legal notice demanding the return of the money, not demanding to appoint the arbitrator.
It's not there.
No, it's not.
There are two notices. One is the one.
Where's the letter? That's why this court asked the
question. I pointed out to that specific. At page 44 is that notice only.
Where is sought arbitration?
Malaj, may see page 47. Page 47 is the particular point in my notice, clause point 9. Our instructions are that as you, the above addressee, has failed to perform the work as per the agreement and has failed to return the security amount despite repeated requests and regular reminders made by our client, the same shall constitute as a dispute in terms of clause 7 of the agreement, which is reproduced herein below. In the given facts and circumstances, you, the above addressee, is hereby called upon to refer the disputes to an independent arbitrator for adjudication upon the receipt of the present notice, failing which we have instructions to initiate the appropriate proceedings. But we at the very next page, Annexure 9 is their reply, in which they, in principle, denied the execution of the agreement, which they have now withdrawn from, and now they are admitting the execution of the agreement, and hence I am before my lords after expiry of the statutory time of 30 days. My lords.
Anyway, so you decide to name arbitrator.
No, my lord, otherwise also this petition is not maintainable, my lord.
Why?
My lord, the party here party is the. There are two respondents, my lord.
Where two respondents in the petition?
In the petition, my
One
lord,
is
there are
Mr.
two
Eric India,
respondents.
and one is Mr.
Yeah. And other is Mickey Pasa.
Mickey Pasa.
Yeah. So.
But the agreement was executed by only the respondent number 1, my lord.
So we'll confine it to respondent number 1.
My lord, the respondent number 2.
The respondent number 2 has.
Are they part of one entity? A partnership or something? No.
No, my lords, there are two individuals. If my lords may see, page 25 of the petition, my lords, is the agreement, second page.
Yeah.
Page 25 on the top, my lords, first para.
Yeah.
At previous page is the first party, that is the petitioner.
Yeah.
And at page 2 is Mickey Pasa, son of so-and-so, so-and-so. And in the very next line, my lords, in the last, and Eric Kindai, so-and-so. My lords, though he has not signed the petition, but at page 26, clause 2.3, my lords, the amount of 30 lakhs which was agreed to be paid has been received by Mr. Eric. And at the last page of this very agreement, he has signed as witness in the presence, my lords. It is not even in the witness. It is not stated that he has signed as the witness at page 33. If my lords may see at the bottom, on the right hand side, in the presence of one Eric in there.
Yes.
My lords, his name is there. He signs as one of the.
See, Mr. Nath, you take it before the arbitrator.
Yes.
Whatever dispute you have, you try out there. The scope 11.6, not going to.
My lord, that is
very limited. We're not going to see whether dispute or not. We're not going to go there. The request has been made. You have resisted it. That's all.
But my lord, as per the condition of 7, my lord, it has not been complied with, my lord. I may be allowed to read, my lord. This is not completely read, my lord.
Read it.
Any dispute or difference arising out of or in relation to this MOU shall be at the first instance settled expeditiously and fairly by the parties thereto. That has not been done, my lord. Number 1.
Yes.
That never has been done, my lord. In the event that the parties are not being able to resolve the same within 30 days of the written request by any disputing party to call a meeting where attempt has been made in good faith to resolve the dispute. No meeting, no.
My lords, if I may just.
Not call for any meeting also, my lord.
Going by the wordings of these very lines, my lords, it says, in the event the parties are not being able to resolve the same, the disputes within 30 days of a written request by any disputing party. My lords, any disputing party, and I will bring forth the fact that
with to
both
call
the
a meeting, my lord.
Let me just read it out. My lords, Annexure 6, page 37 is my first legal demand notice which I had issued to them.
Yeah, Mr. Nath, look, just technicalities aside of this agreement, the thing is that it says, now when was this petition, when was this matter filed?
My lords, in October 2025.
Yes.
This filed within time, my lord. That's
not within time. But the thing is that there's enough time for you. There's no hard and fast rule. You say, fine, that's what agreement. You reach out to them again.
My lord,
you reach out to them after.
My lord, I have tried to call.
After this was filed, no.
I have tried several times, my lord, to complete the task which I have been given. This due to some legal processes, my lord. The works were stuck down in one.
That is a merit of the matter. We're not going to go there.
My lord, the thing is dispute arises because of this.
Since there are disputes which are, remain unresolved, the only thing they want to go arbitrate.
The dispute arises because of this only, my lord. And that time was not given.
That's 6 months time was given since I received their.
What is the total amount of consideration involved?
My lords, around 26 lakhs recovery is what we are seeking.
That's all.
Yes, my lords.
Yes. Yes, Mr. Nath.
My condition is this, my lord, that is as per the agreement, terms of the agreement has not been complied with, my lord. No meeting was called for. It is clearly understood by the terms, my lord, that first it has to be taken fairly to resolve the dispute. If in that event it's not resolved, then a written request has to be made. That request has to be made, and a meeting should be called. That meeting has not been called, my lord. And demand notice has been sent. My lord, notice has been sent as a demand notice, my lord, not as a notice to resolve the dispute.
My lords, I'll just show the fairness on their part for which they've been trying to agitate. My lords may see page 41 is the last page of my legal demand notice which I had sent, my lords. Starting from page 40, point 11, my lords. Page 40, my lords.
Yeah.
Well, it's the first notice I had sent to them that in light of the aforesaid breaches and violations, we hereby demand, as a consequence of breach of agreement dated so and so, owing to the willful and deliberate default as narrated above, we call upon you to return the part security payment of 26 lakhs. Did
they reply to this?
Yes, my lords. At the page 42, my lords.
Yes.
My lords, starting from the substantial part at point 3 at page 42 and Exhibit 7. That late, I'll start from the para 2, my lords. That of being in the possession of the above said land or quarry of your client company has first approached me to do business together, and that your client will invest in the project. Point 3, that later on understanding your client then prepared the first draft agreement MOU, in which after reading the draft agreement then I am satisfied and I told your client to prepare the final agreement. 4th point, that your client have prepared the final agreement but after preparing then told me to sign, and on trusting your client and without looking into the final MOU, then I signed the MOU blindly thinking that it will be the same as draft MOU shown earlier to me. 5. Later, after obtaining a copy of the final MOU after a long time after providing by your client, and after going through with the MOU and after comparing with the draft, I was shocked to see that main MOU is totally different and with the draft MOU, and some of the clauses that was agreed in the draft MOU were not there in the final MOU. Your client have cheated me for this or their gain, and the final draft is a fraud one with the intention to harass me and make my business down. Further, at next page, my lords, further in the draft MOU, it was agreed that your client will pay an amount of 50 lakhs to me, that is 30 lakhs at the time of signing of the agreement, and to be transferred to the account of Shri Eric, and the remaining 20 lakhs to be paid after the commencement of the agreement. And more so, the amount of 50 lakhs will be adjusted against the monthly billing. But your client have not considered this, but instead pay only a sum of 26 lakhs, and that too in part payment and not in one shot. Well, these were their bona fides when they replied to my notice. So at no point I could have had an amicable resolution when they go on to.
Let it go. Your name,
please, my lords.
Yes. We'll give you 1 week's time to agree, or the court will suggest one. We can get some instructions. Advocate also ready to do if we are agreeable.
Please.
That has to be agreed by both the parties.
Of course,
yeah, fine, my lords. If any independent lawyer can be.
Independent lawyer. Just discuss.
This amount is small also.
Please, my lords, that is my.
I'll just discuss with my client, my lord.
Yes, take down on hearing counsel of the parties. This court of the mind to appoint independent lawyer to be an arbitrator in the instance matter. So parties are given 1 week time to take instructions. Others will recommend.
Please, my lords. Lords, if I may request for any date on Thursday, so I may be allowed to join through VC.
You take a date.
Please,
I love this.
Item number 2.
Please, Lordship, I pray for some accommodation, Your Lordship, in this matter. I pray that this matter may come after 2 weeks, Lordship.
You're for whom? Oh, you're for?
Nehu, Lordship.
Oh, Nehu.
Yes,
Okay.
Yes, ma'am.
Yes, Mr. Day.
My lord, this is a case, my lord, where
when
paying for
2 weeks, Lordship.
When?
2 weeks. 2 weeks.
2 weeks. Okay. On the prayer. Esdhar. For this Paul Nehu. This matter of 2 weeks, yes.
Item number 3.
My Lordship, today I have filed my rejoinder, so let this matter come up for hearing.
2 rejoinders?
Lordship, there are rejoinder for respondent number 5 and 6 and 3 and 4.
Both of the hearing?
My Lord, may I pray, my Lord, let them come up for admission hearing. The urgency is there, my Lord. Petitioner is misusing the license granted to him, despite of the fact that there is a condition. Yes. It may come up subject to Lordship convenient any date next
rejoinder has been filed by the petitioner to the affidavit of the respondent. Stop. Next Mr. H. Sanreso, Leonard Senior Counsel, on behalf of respondent number
3 and 4.
3 and 4.
Therefore, submit as a matter, as there's some urgency in the matter, the case is some urgency, the matter will have admission hearing. So he has allowed this after 1 week.
Therefore, respondents 1 and 2.
Lordship, the interim order may be continued. Lordship, the interim order may be continued.
Interim order to continue till next day. Yes.
The petitioner is supposed to file rejoinder.
Yes, Lordship. Lordship will not be filing a rejoinder, Your Lordship.
Already filed?
No, we will not be filing, Your Lordship.
After taking so much time?
Let this matter come for hearing.
Ms. L. Panjam submits that no rejoinder so will be filed. Accordingly, this matter for hearing on so and so.
Obliged.
5.
Lordship, here the affidavit has been filed and there was also a direction for the concerned officer to be present, my Lord.
Yes, where's the officer?
He's here, my Lord.
See, this is not that we're calling you here to punish you something. It's just to ensure that this matter was filed since when, and the government advocates have been filing affidavit. So that's why this court decided if that's not filed, you be present, from your record will dispose of the matter. You received a copy?
I've just received today
morning. What's your name?
Saljagan G. Mohammed, sir.
Okay, so
Yes, G. Mohammed.
Present today. You're the BDO of?
Batabari, my Lord.
Yes, stop. Different court as directed by order date 14/5/2026. Stop. Next paragraph. Mr. Kivarashri submits that affidavit has since been filed on behalf of the respondents.
Respondent number 6. Yes,
yes.
my Lord.
Now, you want to file rejoinder?
I'll file my rejoinder.
My apology, my Lord, I couldn't find, my Lord. We drafted the affidavit, my Lord, because last month I was in, my Lord, leave, my Lord.
You're for respondent number 7 and 8?
Yes, my Lord, 7 and 8.
Yes, okay.
Affidavit already they have sent for signature, my Lord.
Yes, Mr. S. Hassan, S.K. Hassan for 7 and 8. Somebody due to the bereavement that he suffered, the affidavit not been filed. He please allowed 1 week's time to file affidavit. Yes. It is a matter of 3 weeks to allow, 2 weeks time thereafter for rejoinder. Of the personal appearance will dispense with you. You don't want to see, we have to call him to make the affidavit come.
No,
otherwise,
another difficulty, my Lord, because there was some medical emergency, so he was on leave for 2 months.
6.
Yes. And it's connected. 5 and 6 are same.
5 and 6 are connected.
6 are there. You qualify.
Well recorded.
Similar. Diplo.
Obliged, my Lord.
Yes.
7.
1 month. Yes.
I'm appearing for respondents 1 to 6. Here we are required to file an affidavit. Hence, I plead for 2 weeks' time, Your Lordship, to file an affidavit.
1 to 6. Where's NZ in country? 7
Yes,
to
Your
10.
Lordship, state is making a similar prayer, my Lord. We're praying for 2 weeks' time.
My Lord, that's not a objectionable part. My Lord, I have a small submission. Last time we sat for Lok Adalat, my Lord. So all the parties were present in this Lok Adalat. So certain indications were there, my Lord, for compromise or settlement. My Lord, if it is can be sent for mediation, my Lord, some purpose may
what is the dispute about?
Dispute about the land taken by the defense
the mediation never with the land defense and never concede. Let them file affidavit, we'll see. Yes.
But we can sit for once.
Well, let them file affidavit first. We'll examine whether it is, it can be some mediation. Just wait for the 2 weeks time around for affidavits. Expected next day, the affidavit should be on board.
Much obliged, Lordship.
Yes.
8.
Please, Lordship.
May I please, Your Lordship?
Yes.
Your Lordship, this matter is a connected matter with 3 others, which is listed tomorrow, Your Lordship. So I'll be filing the affidavit along with
Difficult if they were to file an affidavit, Lordship.
There are 4 of them, 4 matters.
4 matters. It's listed tomorrow.
Please, because on the last occasion, perhaps because of your Lordship's leave, 3 matters.
Let's see, okay, just tomorrow.
They-
This is matter tomorrow, yes. On the prayer of the parties, yes.
9.
Obliged.
May it please, Lordship, we have received the additional affidavit filed by the respondent number 3.
Yes.
And in view of the additional affidavit, if the respondent number 4 and 5 do not have any objection,
Who filed
then
additional affidavit?
We did the state, the Lordship, in compliance to Your Lordship's directions in the last order.
You disclose the amounts.
We've disclosed the amount, so nothing remains, Lordship, in my
the
submission.
matter may be closed, Your Lordship.
Who's leading you? The matter will be closed.
Kharsad.
Yes, you know your name.
M. Mautho, Your Lordship.
MS M. Mautho, Learned Counsel for the petitioner, submitted view the additional affidavit filed by the state respondents, wherein the terminal amounts have been disclosed. The matter will be closed at this stage.
Much obliged.
On the submission of the Learned Counsel and on the which is concurred to by the
Grateful, Lord.
10. May I please, Your Lordship, we are yet to receive
Who's
instruction.
appearing here?
I'm
You or Mr. Abraham?
Abraham, but Your Lordship, so many correspondents are there, yet to receive instruction.
So you called a video. What's his video?
No, pension matter, regularization and consequential.
Department, Lordship.
Health Department, Your Lordship.
No instructions received since when have you sought instructions?
Since it was, since after vacation only it was filed.
Notification meaning?
Means February. It was filed. Because all correspondents are there.
MSS Barasaji today, the MSS Barasaji, Leonard GA for respondents 1 to 8 has submitted that they are still to receive instructions, even though requests have been made since.
February I have filed.
17 February, 13 May,
2026 of
24th April.
Yes, this court this court has noted this fact of next file. Therefore, directed that if the affidavit is not filed within the next 2 weeks, the concerned officer shall does not if the instructions are not received or affidavit filed within 2 weeks, the concerned officer, that is respondent number.
My lord, here the personal is the personal department, that is respondent number 2, Lordship. Because this
one number 2, who's number 2?
The personal, Lordship, secretary to the government number personal. Page 4.
This from Tura or from Shillong?
This is from Tura, Lordship.
Who's
Personal.
respondent? Who's respondent to give instructions?
Respondent 2, Lordship.
Not 2, because he was not regularized.
That is why the regular has to be done by the respondent.
Regularization is lying with respondent number 2 now.
No.
Then?
My lord will kindly see, Lordship, page 26, Lordship. This is the letter issued by the respondent number 2.
Yes, he is retired also, Your Lordship, in 22.
26, retired.
He is
22,
retired,
Lordship.
and his service is confirmed
And I
also,
am
Your
real, my
Lordship.
lord have passed one judgment in a similarly situated case, Lordship. My Lordship has given a direction.
Please to pass any order, Your Lordship, since they are not cooperating, and petitioner has retired in 2022, and his service is confirmed in 83, Your Lordship.
Instruction not received. After that? No. Yes. Expected next date positively after it should be on board. Yes, what about EB Pasa? You filed?
Receive, Lordship, I'll be filing.
Yes, EB Pasa for phone number 9. Submit the instruction to receive, should be filed, and after it will be filed within 2 weeks.
11.
Actually, it's still in service.
No one, she related. Item number 9 also pension matter, Lordship. Here this is here also, this is a second round of litigation.
Where's,
11, my lord. My lord, my lord, I'm
instructions
paying.
received?
My lord, we have received. My lord, affidavit will be on board, my lord, in 1 week time.
Yes, MSR only placed for 2 weeks time for affidavit. Similar prayer by E. Prasad. It is up to 2 weeks. Yes.
Hello.
In those cases we receive, we have not got instructions for 5-6 months, then that is.
We are ready with the affidavit.
Yes.
Please, Lordship. This is appointment to the primary teachers, but without following the norms of the NCT.
We have already filed the affidavit. They are supposed to file the rejoinder.
No,
don't talk about affidavit. What do you want now?
This matter can be decided, yes, because it's not recorded in the affidavit. They have admitted that the petitioner was.
No, we have not admitted any such thing. You want
to file rejoinder?
The last date was today. Was the date fixed for filing the rejoinder, Your Lord?
On the last day they have submitted. Kindly see their affidavit, my lord, in the page 13.
No. You want to file rejoinder or not?
Not required, my lord.
Not required.
Then we'll
okay.
fix it for hearing. Your Lord.
Then we'll have it on after 1 week for division hearing. Yeah. After it's since been filed by the respondent, there's a matter after 1 week for division. Oh no, sorry, Mr. PD now submits that rejoinder will not be necessary and prays that the matter be disposed at the division stage. Stop according to the matter of division hearing after 1 week. Yes. Who's this matter? West MSOI Bank.
My lord, I was supposed to place the affidavits on board by this date, but my lord, I couldn't because there were certain mistakes in the annexures. These are connected matter from 13 to 23. My lord, I need just a week's time to correct those mistakes that we made in the annexures.
1 week for the tax space allowed. Expected next year the affidavit board. Yes.
Yes, my lord.
24.
Mr. Yubin, other side. For petitioner. Yes, you record the name. Yes.
24.
Yes, who's there for a petitioner?
24.
My lord, AG is on legs in the other court, my lord.
Where's the petitioner? Any urgency here? Any interim orders operating?
My lord, I'm particularly not aware. My lord, Mr. Pandey is.
Are there any interim orders operating here?
No orders operating. My lord, in this matter, the petitioner had to come back with instructions as to whether they want to withdraw the matter in view of alternative remedy.
Right. Consumer for is that.
Yes.
Where's the Mr. Chanda? Oh, what is this? From Mr. Paul's chamber. Nobody is online. Listed. We listed next week.
My lord.
Not request the petitioner this next week. Yes. You receive instructions. It is matter.
I'm praying for a week's time, or at the end of the board, Your Lordship, Mr. Chanda is in court 3, Your Lordship.
Next week.
25.
Please, Your Lordship, I need some more time to file my rejoinder.
Lordship, it's been a month since we filed our counter affidavit.
You for which respondent? You for which respondent?
State Lords.
State.
Director of Social Welfare. Yes,
This is against social welfare.
No, Lordship. Only 3 respondents are there.
Only 3 respondents here.
Director of Social Welfare.
No, Deputy Commissioner, Deputy Commissioner is Jayantia, West Jayantia, and State of Meghalaya by Chief Secretary.
All respondents, my lord.
All respondents.
Respondents.
Yes. Have you filed the affidavits?
Lordship, I need 2
Have we
weeks time.
filed the affidavits? Yes.
Yes, Your Lordship.
Yes, my lord. We filed our counter on 6th May.
When will you file the rejoinder?
After 2 weeks, Your Lordship.
Further 2 weeks time, it's prayed allowed for rejoinder. Just that.
Obligation.
26.
Please, Lordship.
26, my lord, we have already filed our affidavit. And on the last occasion, my friend has prayed for a rejoinder, my lord.
If any. You file rejoinder?
We'll file it. I'm praying some more time, Lordship. I'll pray.
2 weeks for the time as per allowed for rejoinder. Yes.
Much less.
27.
Yes, you received affidavit.
Lordship. My lord, I filed the affidavit today. Will it come after 2 weeks?
Lordship, I pray the matter may come next week because it's a little urgency is there because here is only for one year tenure.
I can't understand what
there is some urgency in the matter, Lordship. It may come on next week, Lordship.
You don't want to file rejoinder?
No, not rejoinder.
So court submits that no rejoinder will necessary. Contest the matter next week for hearing.
Hearing.
Yes, after 1 week.
Highly obliged.
28.
I please, Your Lordship. Lordship, here I'm appearing on behalf of the respondents. I pray for 2 weeks' time to file an affidavit.
You're appealing for the petitioner?
The petitioner.
Yes, sir, for the 2 weeks' time as prayed aloud.
Interim order.
Interim order, we need to continue till next date, yes.
Highly obliged.
Highly obliged.
Yes.
Lordship, we have completed the service of notice to all the respondents.
I appear for respondent number 5.
Very good.
It's writ otherwise has become infructuous, my lord.
Why you made it infructuous?
Well, the meeting which was supposed to happen never really happened, my lord.
We are challenging the act of the District Council that this order is without jurisdiction. So, Your Lordship, when the act is null and void, then the question of the lapse of the period, the operation of the order does not even arise for infructuous to become.
So, what should do is matter?
Well, you can close the matter, well, because as it is, the order may not be correct, or well, the direction given to me was they were adhered to. The meeting could never take place because, my lord, there was some.
There was a time limit for the meeting.
No, my lord, it was 30th of March, Your Lordship. But then the meeting was
never held till now.
Never held.
The meeting was not held, was at that time, but we challenge that the act of the District Council passing this order is without jurisdiction.
Prayer.
Seeking for a declaration.
Page number 7.
Where's the impugn order page?
Page 14.
40.
14. 14 in the translation copy is 15th. 15.
Performer.
Oh yes, where he's asked another person who's not.
Yes, asking the third party to convene the darbar.
Well, I am otherwise the Mintri of my lord.
Who are you?
I'm one of
why
the
are you dabbling so much? Why are you dabbling so
Nongrim.
much in this matter? So to say, council.
I was directed to hold a meeting. Well, the meeting never
why?
transferred.
Well,
I am the ride of
they
Nongrim, my
conferred
lord,
authority on
and
you to
the
hold a
village
meeting.
falls under my.
Lordship, Lordship,
Yes.
that's not right. The link falls under Ranokran, Lordship. He is one of the Mintri.
It doesn't matter, but then if the meeting is for the Shnat, then the Sardar should have it.
Because the purported Dorbar, Your Lordship, is only limited to 23 clans, Your Lordship. Other residents of Shnat Ring were not allowed to attend.
This is the same matter where the orders have passed that. Not
Your Lordship, here we have not even hold a darbar from the time. From the time we received the sanat, I became the Sardar. I'm not hold any darbar. Now, how can they come presuming that I'm calling the darbar only for 24 clans? They only pass this order for third party.
Yes. Well, what does the CM have to say?
My lord, this is a totally wrong order, my lord, because the direction is for one Hamsilat Belempada. He is nobody. He has not come as a Mintri or anybody.
Exactly.
My lord.
What is your connection with the council?
Well, I was given a direction,
Why is
my
your
lord,
blue-eyed
and the
boy
meeting
to
never
hold
happened, my
meetings?
lord. Only thing is that my lord, I'm one of the Mintris of Right Nongrim.
No.
But here he is a nobody, my lord.
This order, I'm talking about this specific
Yes.
order, not in confirm that, it's like picking up any Tom, Dick and Harry.
Exactly, my lord.
Like tomorrow I say, Mr. Gautam, go and convene meeting.
If you allow, my lord, it will be a precedent everywhere.
This will set a precedent, my lord. This will set a precedent.
Fact remains, my lord. Meeting never transpired.
See, nobody we're looking at what it says here. So I'm saying, what is the connection?
Otherwise, your lordship is symmetry, but the way the order was.
And the way the orders is addressed to the chief.
Yes, exactly, my lord.
Manner.
Usurping the function of the chief itself.
If
you allow this one, your lordship, will be a precedent.
Has been rendered infructuous in view of the fact that impugn order resistance losses force. This court only notes that the contents of the same are I won't say offensive. The contents of the same are improper, inasmuch as apart from being vague, no details are given as under what circumstances the said respondent number 5 has been directed to conduct this meeting. Be as it may, as the date given therein has since lapsed, this matter is closed. Has been fruitless, yes. And that is
30. Take note.
Yes, he take note. Something's wrong. I think we need some medication.
Much obliged, lordship.
Sending order by WhatsApp. The other case?
Yes.
Yes.
That's true.
Lordship, find the lordship of the record, lordship, that erring staff, your lordship, has been reprimanded, your lordship. It is not the direction of the EC, your lordship. Staff, they are doing whatever they feel like. Process server.
So soon you start terminating employees by WhatsApp also.
Your lordship, you're being reprimanded that these actions should not
That shouldn't be done.
continue.
Suppose tomorrow then you just sitting playing with your WhatsApp, with your phone, and you want to terminate some officer,
No, your
you just
lordship, no.
on WhatsApp you're terminated.
This is not the direction at all from the EC, your lordship. What compelled the staff to do this? No, your lordship.
Anyway, yes.
Obliged.
Yes.
Your lordship, on the last date, the state took time for this.
Who?
30. But I need.
Who's this? Who the appearing for? That in country? No. 1 to 5 is whom?
She's there, lordship.
My lord, I'm here, my lord, virtually.
No, are you appearing in this matter? Last
My
date
lord,
is...
I'm here virtually.
No. Are you the counsel in this matter? 1 to 5?
Yes, my lord.
Item number?
30, my lord.
You're the counsel.
Yes, my lord. But I'll need a little time, my lord. 2 weeks time I come after the waiting for instructions.
It's going to be difficult now. One day someone appears and
My lord, items number 30 and 31 are connected, my lord.
Okay.
Yes, my lord.
Go to 2 weeks time. Praise Lord.
Lordship,
Much obliged, lordship.
the petitioners here, they have not received their salary, lordship.
Interim orders are there.
Yes, lordship. Order may continue,
Yes,
lordship.
this one is MSL Panjom, however, has submitted that the petitioners, though protected by orders of this court, have not received the salaries. Respondents respond to address the situation. Yes, just after 2 weeks affidavit.
Interim may continue, lordship.
Interim order continue.
Much obliged, lordship.
Yes, who's appearing?
Well, I'm for the petitioner.
Nehu, that means all Nehu only.
Yes, all Nehu.
What's the matter about Mr. Sen? Have you come?
This is regarding, my lord, he is contesting election, perhaps confirmation and NOC from university. Now I have just
contesting which election?
Parliamentary election, my lord. By-election.
Parliamentary election?
Parliamentary by-election, my lord.
not yet notified, but
Not yet notified here, but
no. What is the issue here?
no issue here, my lord. My lord,
Why he's not been allowed to?
No, I have not.
Prohibiting him.
No, it's not like this, my lord.
Yes.
No, it's confirmation, my lord. Nehu is yet to formally confirm his service. So that is done by the EC, number one, and he has applied for NOC to contest the election. That decision also has to be taken by the EC. Now, just now I received the instruction, my lord, that his case, my lord, will be placed before the 194th EC meeting to be held in the last week of June. Both his confirmation as well as NOC.
No, but why should that stand in the way of him contesting then?
NOC is required.
NOC is required, my lord.
I mean, sorry,
he's a regular. If he is confirmed, he will be a regular incumbent of the university.
Now he's not regular as yet.
No, confirmation, formally.
Formally confirmed.
Why can't you NOC at this stage also?
My lord, I think formal confirmation is required.
Is there any way written that you have to be confirmed before,
Yes, there is a rule, my lord. There is a rule, my lord. My lord, I have, as per the rule, I was required to confirm after completion of 2 years, my lord. And as per 1 year, my lord. And as per my appointment letter, I was supposed to confirm after 2 years completion of service. I have completed this service, my lord. And but despite this, I was not confirmed. Now 193 executive committee was set, my lord. In that committee, they have confirmed so many associate professor, my lord. But I was not confirmed.
Why?
That no reasons are there, my lord. We don't know for what reason.
Associate professor.
Associate professor, my lord.
Okay.
And my lord, there is, as per the rule, the only confirmation can be rejected or withheld if there is any grievances, if there is any disciplinary action which is been checked by the Vigilant Department. Now, Vigilant Department also has issued a notice stating that there is no disciplinary proceeding, there is no anything against.
Mr. Sen, if he's associate professor, he can't be confirmed in the earlier post. NOC given.
If he's confirmed, my lord, of course. But this decision,
to be associate professor, he had to be assistant professor before.
He's an associate professor. He's an associate. No, he joined university as an associate.
Associate.
Oh, okay.
He has joined an assistant.
Not assistant.
No, my lord.
Okay.
He was before serving, I think, Shillong College.
Okay.
So once it is confirmed, both these issues will be taken up in the next meeting to be held in the last week of June, my lord. Date is not yet notified.
No, my lord, not yet notified, but it's likely to be notified very soon, my lord. In that event, I'll be prevented to file my nomination.
Notified, you mentioned it. Mr. S. Sen submits a letter counsel for the respondents, submits instructions that the matter concerning the confirmation and
NOC for
and the grant of
MPY election
certificate to the writ petitioner for contesting elections will be taken up in the next meeting of the executive council, which is scheduled
last week of June.
For the last
my
week
lord,
of June.
my lord, my submission, my lord.
Mr. HR Nathik, however, submits that as notification may be issued any day soon.
Yes, ma'am.
We get liberty to mention the matter for urgent hearing.
Yes, ma'am.
If the date for elections is intimated. According list after 2 weeks.
My lord, after 1 week, my lord.
No, you mentioned it.
Nothing will happen.
We say list after 3 weeks, but you mentioned it.
Yeah.
Because 3 weeks of June will be over.
That situation comes. Yes.
In that situation is notified, then hearing will take up at 2:30. Any hearing matter.
Oh, bless me.
I don't have no hearing.
Yes.
No, item number 50, it is also for hearing, but I just want to mention, my lord, that for 3 months the petitioner has not received his salary. So if my learned friend can get some instructions from this.
Yes, why
he is not getting his salary?
Working as what, Mr.
He's a work charged employee.
Now we'll take up the matters at 2:30. Mr. Sheikh wants to run away.
Item number, we'll just say
38, 13 and 40.
Yeah.
And 42 and 43, lordship. 43, 42, 43 and
other connected matters.
My brothers also for
connected matters.
After 2 weeks, lordship.
Mother 38, 39 and 40.
I don't. This is.
Your lordship, we were on 50 actually. Mr.
If we are on 50,
Siddiqui is,
yes.
yes, and everybody has not. Anyway, your lordship, we'll find out when he has not been paid for the last 3 months.
Yes,
Your lordship.
item 50. Mr. Siddiqui submitted, though the matters this is for hearing, would like to draw the attention of the court to the fact that the writ petitioner will be receiving the salary for the last
3 months.
Last 3 months.
3 months.
3 months.
3 months.
Yes, stop. Next time, MST Yangi, Bill and AAG submit that he will obtain instructions on this aspect. Yes, just after 2 weeks. Yes. And what we
Lordship, item number 38, 39 and 40. These are the electrification matter, lordship, dead by electrification.
38?
38, 39 and 40.
Your Lordship, I am for the respondent number 4 and 5 in item 38, 39 and 40.
What is the matter about?
This is death by electrocution, Lordship. We are asking for compensation, Lordship.
From that company?
Yes,
Company as well as the MSCL, Lordship. both.
FEDCO, my lord, and you are saying FEDCO is
when next week?
responsible.
My lord, after 2 weeks, Lordship. Next week also, no, Lordship.
After 2 weeks, yes. On the prayer of the parties, yes.
Submit.
Then item number 42, 43,
44,
My
45,
lord, 42 to
46.
47, my lord.
Yes,
Yes.
ma'am.
What matters are these?
this is fair trial.
EDS matter, my lord.
They're ready for hearing, correct?
My lord.
Yes. What do you want?
Next,
Up to 30?
next week, Lordship.
After,
Well, item number 37, my lord.
after 1 week, yes. Yes, Mr. The
Well, item number 37, let it come after 2 weeks, my lord. I've already received the instruction. We can dispose it off, my lord.
Okay, better do it by physically. Yes.
Yes,
May please, Lordship. Item number 36, my lord. I am for private respondent. Matter may come after 1 week or 2.
Yes.
This is no matter. Let it also come after 2 weeks, my lord.
Lordship. No.
Okay, okay, yes. Matter remains. What? Sase.
Lordship, in this case, I am the petitioner.
Which case?
36.
Item number 36.
He's seeking time there. You're a petitioner?
Yes, sitting time.
You're the petitioner?
Yes, yes.
In 36?
Yes, yes.
Anjan Marak?
Yes, yes.
You have no objection for the adjournment?
No.
Okay. Yes. That's all. Which matters, any hearing matters still surviving? There's some allergy to having hearings after lunch.
Your Lordship, in item 38, 39 and 40, I am appearing for the
Yes.
respondent number
Record
4
name
and 5.
Ishwar Mohapatra. Yes.
Yes, my appearance
Yes,
is
and 40. Right.
What is the date given, Your Lordship?
You ask the court master.